Hi, everyone. Happy Monday. Join Jackie on Mondays at 10. Go live, give you a short snippet of legal information. Most Mondays, funnily enough, how many Mondays happen to be a public holiday? But anyway, today's topic is about, of course, doing wills, but in the context of separating. Now, when you've just separated, it's probably not at the forefront of your mind about succession planning and doing a will because there's so many other things going on emotionally at that moment. But it is pretty important, particularly if you're married. So if you're married, but you're separated, your spouse still has the greatest claim on your will. So under the laws of intestacy as well, which is if you don't have a will at all, your spouse gets everything unless you've got a blended family. So if you are separated, whether you've done your financial settlement or not, you should do a new will. Even after you've done your financial settlement, if you don't do a new will, and your previous will either said everything to your spouse, that doesn't rule them out just because you've had a financial settlement. Your will still stands as a legal document as your last wish about your testamentary wishes. It's not like marriage where it invalidates a previous will or divorce. So divorce will save you from having to do a new will in some respects, because as soon as you've divorced, it treats the person you've divorced as if they've passed away. So if you'd done a will while you were married, leaving everything to each other and then to your children, if something's happened to you both, the divorce is like a death. And so your spouse leaving everything to them doesn't count, and it goes down the line to your children, which is probably what you want. But divorce does that, not separation. So do think about doing a will if you're separated. There are lots of people out there who are separated but not divorced. They do need a will for their current situation, because even if you're separated, your spouse is actually your next of kin. So think about that also in terms of medical decisions, in terms of what rights your ex has over your life if you lose capacity. So powers of attorney then become relevant as well. Please if you only think about doing this for the purposes of making things easier for your children and your immediate family around you, then do that, because the complexities that arise when there is no will can cause real difficulties for those loved ones that you leave behind. So let's make it simple. If you've separated, do a new will. Do a fairly simple one if that's all you need to get you through until you divorce or until you've got more clarity about your future. But just do one for that period of time. It's just in case of an emergency. I hope that's helpful, or helpful for someone that you may know. If you want to make sure this is seen by someone that you think it's relevant for, please tag their name in the comments, or you can share it with them privately on Messenger. While this is live at the moment, this will be saved onto our page, as are hundreds of other videos that we've done, which is a really valuable resource as a first place to start. So please go back if you've got a legal problem, look at the videos tab on our Facebook page and have a look to see whether we've addressed your problem. If we haven't, please direct message us and ask us. I can do a quick snippet legal information on this on a Monday with Join Jackie. Otherwise, hope you have a great week. Stay warm. And I'll see you next month. I'll see you in July.